My name is Marie-Bénédicte Dembour. I'm a professor of law and anthropology, and it's my pleasure today to talk to you about the research project I am leading called DISSECT Evidence in International Human Rights Adjudication. DISSECT is funded by the European Research Council, and it is an advanced grant which is being based at the Human Rights Center of Ghent University. So why talk about evidence in international human rights adjudication? Retrospectively, I have now found that even in my very first article about the European Court of Human Rights, I was already talking about evidence. Evidence has just been a thread towards my 30 years of scholarship, where I have been wondering, what is it that convinces the court, the European Court of Human Rights, on which I work the most, of some claims by applicants, with other claims not being established according to the court. So I think that despite the fact that evidence is not very much studied, it actually illuminates many processes of what's happening in international human rights adjudication. So once I had decided that evidence was really worth studying, the first question I needed to answer was, what evidentiary regimes was I going to study? And I decided that my study should include the 3 regional courts of human rights, namely the European Court, the Inter-American Court, and the African Court, as well as the UN treaty bodies. Because I'm very clear that even though throughout human rights adjudication, one says that the evidence regime is very flexible, so that there is a lot of liberty and that there are a number of principles which seem to be similar between the institutions. I also think there are differences, and these are worth studying. So what does DISSECT study in particular? The first thing is that it seeks to do a legal analysis of the evidentiary regime of these 4 types of institutions. And what do I mean by that? On the one hand, I mean that we need to look at the burden of proof. Who is it who needs to bring the proof of particular claims? What is the standard of proof? So when will an adjudicatory institution accept that something has been proven and is therefore established, as well as looking at something that lawyers don't always talk about, which is the scope of proof. What is it that can be proven, and what is it that cannot be proven? For example, at the European Court of Human Rights, it is often said that what has been established at the domestic level cannot be looked again by the European Court of Human Rights, which is not a court of first instance. So other questions which are also part of the legal analysis is, what kind of type of evidence is being admitted by the institutions? Basically, the answer is about anything, as long as it's convincing. How it's going to be assessed, and who is going to have to collect this evidence or to submit it. So these are the important questions in terms of legal analysis. However, DISSECT is also interested not just in the legal principles, but also in their, what could be called their political underpinnings. And here, the important thing is that in a human rights case, Normally, the applicant is going to be an individual or a number of individuals. Occasionally, it might be another type of legal person. It can be a state, but normally individuals. And the defendant party is a state. And so you have an individual against a state, and generally that means we're going to have what lawyers call an inequality of arms, as typically the state is going to be more powerful than the individual. In terms of the evidence regime, this is going to have implications that are worth studying. So who is going to gain and who is going to lose from the evidentiary norms which are being applied by the adjudicatory institution? Who has access to evidence? How difficult is it to collect it? When there are costs to bring out that evidence, who is going to support them? And how high are they? And another important question is, if a party does not manage to persuade the court, does that mean that they will have to lose the case? So what are the consequences of the allocation of the burden of proof, part of which is the burden of persuasion? So DISSECT encompasses a doctrinal study, which is a study of the law as law, but also, as I have said, a study of the political underpinnings, which means that then it goes towards being a critical legal study. Critical in the sense that it does not just look at how things are, but it also normatively assesses them and looks at power relationship. So how can one study the law and its political underpinnings? In a number of ways. So what DISSECT is going to do is, first of all, an examination of the case law using what I have called a dissecting method of analysis, which means that we're not looking only at the judgments, although these are very important, but we're also looking at other things, such as the submissions of the parties, the hearings. To supplement that, we are conducting interviews with key actors. These might be legal representatives and judges, but NGOs, these type of actors who also are part, if you like, of the legal process, as well as conducting ethnographic fieldwork. As I have said in the introduction, I am a professor of law and anthropology. I have studied law, and I think it's very important to try to approach an institution in its context and to understand how it works. In reflecting about my methods of analysis, I have come to think that really what I am doing when I try to work anthropologically on legal material is that I'm applying 4 anthropological mottos, if you like. And here you have an illustration of the first anthropological motto, which is that as an anthropologist, you look at things empirically. And here you have someone who is bending on the ground and really examining very precisely the quote with the image is inspired by me by Thomas Eriksson, but grains of sand on the ground. So you look at the minutiae of the social facts, and then once you have done that, you take a more holistic view, and you take you try to see what's happening overall, but your basis is really the very small scale examination of your data. Second anthropological motto is that you very much keep in mind that there is often a gap between the theory and the practice, between what people say or think they do and what they actually do in practice. And of course, that could be the case as well for judicial institutions or for legal representatives. So it's trying to capture what is really happening rather than what one thinks is happening. Anthropology also pays great attention to silencing gesture, silencing practices, is aware that some people, for example, typically women compared to men, are being muted, do not have the same voice, and do not have the same possibility of impacting what's socially happening. And again, this is something which will be relevant to the study of evidence. Here, the illustration shows a woman being sidelined, but that also goes to race and to class and to education, so cultural capital, etc. And finally, what is very important for anthropologists is not to stay at the surface of things. To do this work that I've been talking about, you need to dig, and you need to dig always further. So these are 4 mottos which also inspire DISSECT as it conducts its research of evidence in international human rights adjudication. So I have told you we're going to have 4 institutions. They're going to be studied by different researchers. This is an agenda which is far too ambitious to be conducted only by one person. On this picture, you see part of the team. So on the right, you have Anne-Catherine Speck, who is studying the evidentiary regime of the European Court of Human Rights. The tall man third from the right is Genaro Manrique, who is studying the evidentiary regime of the Inter-American Court of Human Rights. And on the left, we have Edward Morimi, who is doing the same for the African Court on Human and People's Rights. For the UN bodies, at time of speaking, we have not yet hired a researcher, so we'll see later who is joining the team. So this is for the study of single institutions, but DISSECT is also interested in conducting a cross-institutional study where we compare what is happening between the different institutions, so that we're going to have a comparative doctrinal study, and we also have a more general reflection about the political underpinnings of the evidentiary regime, which leads us towards a more general critical legal study. So in terms of the doctrinal study, that means that there will be a doctrinal comparison. That's going to be conducted in part by Nelle Schult, but also by other researchers, again, to be announced. We also have researchers who look at more thematic issues and do so from a number of institutions. So Jill Alps, who is on the right on the picture, is looking at what's happening with evidence in Mediterranean pushbacks and looking at the role of lawyers as brokers of evidence. Nina Koloratnik is looking at the difficulty that indigenous people face when they have land claims and where they have to put across their indigenous knowledge, which is often based also on secret on secret knowledge, and that needs to be submitted and understood and taken into consideration by Western epistemology-based institutions. Rua Makumbe, who is on the left of Nina, is looking at the development of digital open source evidence and their use in international human rights adjudication. And Emma Varnagi on the left is examining what happens when evidence is not accepted, is not really being considered by institutions when there are claims of racial discrimination. She's looking especially at Roma before the European Court of Human Rights, but also possibly before UN treaty bodies. Now, once this work has been done, we'll get to yet another work package, so work package 5, which is about submitting practical recommendations, identifying practical recommendations, and then talking about them with significant actors, including the institutions studied. And also there will be a work package 6, which is really a general reflection on evidence, power, and truth. The ambitions of DISSECT first is to clarify the law which has to do with evidence. As I have said already a number of times, it is flexible, and this flexibility almost inevitably means that it is also messy. It's difficult to know exactly what is required and how it is being assessed. So trying to understand what's going on is DISSECT's first ambition. Second ambition is to expand the area of critical legal studies, which has not very much looked at evidence or at truth as a concept, and so helping to add a dimension. Third, DISSECT would wish to develop international human rights comparative studies. This is beginning to be done, for example, to compare the 3 regional courts, but it's still not very much done in depth, so that's something to which DISSECT can contribute. DISSECT would also like to influence practice. I've told you we will want to come with practical recommendations. In terms of research and how we do research, we will develop further what I have called in the past a dissecting method of legal research. So how can we really go in depth in studying cases? What can we do with cases, looking at them in great depth, so that in a sense they yield more than just the possibility of doing very interesting legal studies. And finally, and in line with that as well, generally developing socio-legal studies. So this is what DISSECT is about, and I thank you for having listened to me.